All right, your aggression by,
Opposing counsel.
okay, verbally?
Physically.
Oh my Lord.
Okay, what specifically?
He was stepping, the woman, Lily, who just left the courtroom, even if she shouldn't be involved in the conversation, I respect this, but he was physically stepping in front of her and pushing her back.
William Branson versus Heather Collins, 2402269.
Ready, Your Honor? Good afternoon, Your Honor. I'll represent Mr. Branson, who sits to my right.
All right,
Good afternoon, Your Honor.
good afternoon, and your name, sir, please?
William Branson.
All right, thank you. And counsel?
Good afternoon, Your Honor. My name is Micah Dalbala, appearing on behalf of the defendant. She did request 8:30 in the morning at the last hearing because she works at 11:30. I didn't get notice of adjournment till Friday. I sent a subpoena to a witness on Thursday that I filed with the court. I've been trying to facilitate adjournment, but I have to officially ask the court for that.
Okay, so the court will note that I originally, we were trying to do a date not today, and then counsel was going to be unavailable. And then I picked today's date, and it was my mistake of picking 8:30 because I had already committed to serve as a panelist on a career enhancements day at Wayne State University. So I was there this morning, and it was my fault that I set that time. So once it was determined that there was a conflict, then communication was sent to your client. It was sent to you once we received your appearance. So that would be why you received that information on Friday, because that's when we received your appearance. And so there was plenty of notice provided to your client where she could have potentially just asked about going into work late, having somebody cover for her for an hour or two, I'm not sure. But before we get to the request for adjournment, did everything occur that was supposed to have occurred regarding the
You ordered in.
let's see here. Number one, I ordered the parties to brief the issue of no certificate of occupancy and collection of rent. Counsel, did you submit yours?
I did, Your Honor. It's titled Memorandum of Law, and the date of filing was 2/14/2025 at 10:45 a.m. I believe both sides have submitted memos, Your Honor.
Somehow it's not showing in here.
I can approach with a copy for the court.
Okay, just one moment. And
Or
then,
we can email it to you now, Your Honor, if you want. Whatever is more convenient.
well, then I also indicated that
An inspection?
there was, yes, counsel, please let me make the record, that the parties were going to meet where Mr. Branson, they would have an independent, they could each have an independent person, so Ms. Branson was not to be present. And there was supposed to be an independent person there with Ms. Collins to go over what the issues were regarding the repairs that need to be made. There was permission to take some photos as well, but they were not to video or photograph each other. So did that occur? Because I believe that was set for Saturday, the next day, Saturday.
Friday at 5 p.m.
Friday at 5 p.m.
Yes.
That's right, okay.
In fact, it did occur. And what happened is that.
No, I don't want to know what happened. I just want to know if it occurred.
It occurred with the assistance of the Wyandotte Police Department.
I must state something for the record.
Okay.
Plaintiff was actually, I don't have a copy of a written order and I wasn't here, so I'm at a little bit of a disadvantage, of course.
Okay.
Plaintiff, of my understanding, was in violation though because he brought 2 police officers with him. This woman's already being, sexually harassed by her landlord. And
Hold on.
Sorry.
Hold on a moment.
For safety
Your
reasons.
your client had made allegations regarding various types of harassment or assaults, indicating that those are being investigated. I don't have any information or basis for any of that. So counsel, please we're not gonna go there.
I'm not trying to bring those claims to this court. I'm trying to explain that under the order, and as you described it, there was supposed to be one independent person with each party. She's in significant emotional and mental distress because of her living situation. And then she has her landlord come with 2 police officers instead of an independent person. So plaintiff is in violation of what the court ordered. And it's having a deteriorous mental effect on my client, who's now being put through the ringer in court that, she's not credible because she's suffering from abuse.
Your Honor,
Well, first of all, I haven't said that your client's not credible.
Yeah.
I haven't said that at all.
Okay, sure. Fair enough.
may I address?
But I also, I will say from an outside perspective, that I don't know that there could be any more independence, as far as independent individuals than the police department, because they don't have any, stake in any of the games.
I appreciate that.
But the
And she's
issue.
been made aware of that, but the problem is that it's a very tenuous situation and the court ordered that one independent person come. And that's not what happened. The landlord brought 2 police officers with him. And that was video camera evidence. Even though it's from the police, there's a cam. They were a
body cam.
Yeah.
Okay, well, when I said no video, I meant I didn't want each of the parties to video the other party, thereby exacerbating any issues that were going on. That is what this court was intending, because your client was improperly recording the proceedings when she was here last time as well.
I understand.
So I wanted to make sure that neither party was exacerbating any issues or trying to instigate any provocation from the other side. That was why this court ordered no videotaping of the other individual. However, they could take photos of whatever issues needed to be repaired, but they didn't need to have the other person in the video or in the photo.
If I may
So my first thought is that if there's 2 police officers there as independent witnesses because they don't have a stake in any of it, I'm not sure how there could be any more independence by that. Did your client have another individual there with her?
Honestly, I'm not sure, but she certainly didn't call the police. And if the order said you can have the police present, then I wouldn't even be discussing it. It's not that I'm trying to cause an issue. I need a simple adjournment. I need to get some fairness for my client. And
I'm not saying I'm not going to grant the adjournment, counsel, but I'm just trying to understand if any of the things that this court had ordered occurred.
that's hard for me to know precisely.
Well, but I'm also going to say this, that I don't know that there's a violation of the order, of this court's order regarding, and really, I didn't say they had to have an independent person. I said they could each have an independent person. I didn't say that they had to have an independent, I didn't say they had to have anybody there. I said, if you choose to have a person there with you, right? Because I thought that would probably be most beneficial for both of them. It has to be an independent person. And there are what they call civil standbys, right? So there's individuals that may be going to a property to, if the court ordered they can't return back to the home, they take the police with them to go retrieve some of their personal belongings or what have you. So I don't necessarily know that that's an improper person to have there during the time the photos are being taken. I'm not sure.
Yeah. Guys, Judge, I think the reason she's objecting is because we've submitted the body cam of the police officers. Now, let me back up.
Wait, where did you say? Where did you submit the videos to?
Your Honor, there were,
No, Mr. Foley's on Zoom.
No, Mr. Harper.
Okay.
Mr. Harper.
Where did you submit the body cam to?
Your Honor, what we've done is that I've answered her motion to.
No, counsel.
It's part of
Where did
it.
you submit the body cam?
It's part of our response to her motion to dismiss. It was emailed.
Who filed the motion to dismiss?
My
Miss-
client filed an amended motion to dismiss.
And so
When
we,
did she file that?
Well, she does not understand the court system or e-filing, so I filed it as an exhibit because a brief was ordered. So my whole position is very convoluted. I have a brief and I have an amended motion to dismiss attached to it.
Your Honor, if I may,
Okay.
the motion was properly filed. It was properly filed, but not timely. You had ruled on that already. So you had a copy of the motion and then you.
Well, no, I didn't rule on the motion to dismiss. I say that I wasn't going to hear the motion because it wasn't properly, there wasn't proper notice. So I didn't dismiss the motion, I didn't do anything on that. I simply indicated that I was not going to hear that on the 11th of February because it had not been properly noticed, or hadn't been proper notice. So I didn't rule on the motion. So let me just clarify that for the record. I did not rule on the motion.
That's correct, Your Honor. I wasn't inclining to say to you that you had ruled on anything. I was merely saying to you that when she appeared here in court, they took the motion and they filed it. And I was about to say exactly what you said, so I'm not going to repeat it. But in answer to your question, Your Honor, we had submitted a Dropbox that contains the body cam of the police officer, and it was emailed on Friday at the same time that we filed our responses to a D. Peryaski, P-A-R-Y-A-S-K-I.
Oh, yes. Yep.
Yep, at wine.mi.gov. And so the drop link that's there will allow the court to perfectly view the body cam video. And I think, let me tell you why you need to view the
Well, hold
body
on.
cam.
I'm going to tell you why I'm not going to view it right now because it's not properly submitted as an exhibit to a motion. I'm not going to view a video that's just been submitted as a response to a motion or that's been emailed to the court because there's still the evidentiary rules that the court needs to follow, and that's not properly before the court right this moment,
May I address that?
okay?
Like I said before, this was in response to the motion to dismiss. And hopefully you'll take an opportunity, because I know this was filed late on Friday, to review all these documents between now and the next time we return. But in terms of evidentiary, Your Honor, it is not hearsay. It's not an acceptance.
Objection, we shouldn't be going into the details of the video.
I'm not
Sorry.
saying that.
With all due
Well,
respect.
hold on, the court's gonna overrule the objection in the fact that, it's a bit premature because there's not been a video offered for evidence at this point. I'm stating that the court's not reviewing the video right this moment that was submitted with your response. I don't even have that loaded on here. Potentially, because it was done late Friday afternoon, and there's, probably 15,000 steps that has to happen from the e-filing once it gets put into here, and Ms. Peryaski is out ill, and so it's not on here. So
I understand.
I want to state for the record, I have not reviewed the video, nor am I going to review it right now, because I haven't had an opportunity to review the response, and there needs to be a review of the foundation before the court can view the video.
I agree with you.
So I'm not going to talk about whether it's excited utterance, whether it's not hearsay or anything of that nature. Okay?
In answer to, you had asked when it was filed, and we've answered it. You had asked how it was filed, and we've answered it.
Right.
And then the issue of whether it's admissible or not was raised. I was addressing that specifically.
Right, and I can appreciate that, counsel, but right now is not the time to address the admissibility of it because I'm not hearing the motion right this moment.
I understand that, Judge. All right, so the next item I want to raise is the pragmatic part of this. In our response, we were able to locate the invoice in which my client first went to the city to apply, and it turns out it was in November. So this morning, I had my client go to the city again and request an inspection date.
Objection,
May I finish?
Hold on,
please don't yell at me.
excuse me. I expect that the attorneys are going to address each other respectfully and not yelling at each other.
I would like to finish
So
my
there's really not
statement.
anything to object to at this point, counsel. I'm just listening to what Mr. Dagger has to say.
I didn't get that.
This is the second time that's happened, And Your Honor, I just want to finish
What's the
my
second
statement.
time this happened?
That she's objected in the
Okay,
middle
and I
of
just
sentence.
addressed it, so please continue.
Thank you.
Your client went to the city this morning.
My client went to the city this morning. My client was able to obtain, pardon me, Your Honor, there's a potential witness in the courtroom here who I think is going to be called. And what is your name? I'd like to identify
No,
who she
no,
is.
no, I'll find that out.
All right,
I'll find that out. Scott, can you go find out who? Actually, okay, Ms. DeClala, who is this individual?
I don't know. I haven't seen the video. I don't know.
Yeah, counsel, I'm just asking, who's the woman that's here in the courtroom?
Oh, this is, someone who's assisting me.
She's assisting you?
Yes.
So she's not going to be a potential witness
No,
or anything?
No,
Okay, and what is your name, ma'am?
Ariel, I'm a friend of
She's a
Ms.
friend.
Collins.
Okay, you're a friend of Ms. Collins, but you're not intending
No,
to testify?
no.
And so she's helping you out, counsel?
Yeah.
Does she work for you, or she's,
no,
Providing
she's,
information to the small business.
yeah, and also
I'm sorry,
I,
what?
Filling her in on any facts that she might need because Ms. Collins isn't here.
Okay, well, Ariel, if she's called to testify, won't be allowed to testify then.
I'm not calling her.
No, I understand that, I'm
Yeah.
saying in the future or otherwise, because she's
Yes.
been inside here, so, okay.
all right, continue on, Your Honor. As I was saying, my client this morning went to the city and was able to obtain an appointment for next Wednesday between 9 and 2 to conduct all the necessary inspections for the compliance certificate. What I'd like the court to do, if we're going to adjourn this matter, is that I would like an order of the court allowing all necessary inspections to be conducted by the city next Wednesday between 9 and 2 as regularly scheduled. We have no specific control over the exact nature. Now, Sister Counsel had mentioned that there's a statute.
Hold on, before we get to that,
Yes.
we're going to address this.
Mhm.
All right, counsel, I'm not addressing, C of O, no C of O, or collecting rent at this point. I'm just asking, is there an objection to the city on February 25th between the hours of 9 and 2 p.m. to go to the home to inspect the property?
Yes, because they have to get in contact with my client first. In fact, I have from the city of Wyandotte, enforcement details. She submitted to them a copy of her lease. They were requiring that first. And under city ordinance, unfortunately, I don't have the point, but they have to get in contact with her directly. The city does. I would love to agree to that.
I don't understand what you just said. Do you, Your
The
Honor?
city has to get in contact with Ms. Collins.
Yes.
That's just not true, Your Honor.
Counsel, give me an opportunity, please,
Thank you.
without interrupting.
So this is from BSNA Online. And there's a summary here. There was a complaint, possible rental at the address. The tenant dropped off a copy of the lease and info for request. So now opposing counsel has scheduled the inspection.
Well, no, it doesn't sound as though they scheduled it. It sounds as though the city
Right.
told Mr. Branson when they would be there for the inspection.
Excuse me for misspeaking. It's my impression they have to contact my client in order to schedule it.
And, okay, is there something in the ordinance specifically that says that the tenant has to be present or the homeowner has to be present?
I'm not sure, Your Honor.
May I read the statute, Your Honor?
Okay. You have the ordinance there?
No, Judge, I'm reading the statute she cited to me outside.
No, I'm not talking about.
Well,
the
there is
statute right now.
no such ordinance.
Well, hold
There
on.
is no such ordinance.
Hold on. Counsel, Ms. DeClala, I'm sorry. You stated that your client is required, that the city has to notify your client.
Yes.
Okay, where is that authority?
I'm not sure.
Okay, but you made that statement, so,
I did, yes. There is a statute, that's a state statute. However, I'm not sure the ordinances. Again, what I was saying before was coming from BSNA Online. But under MCL 125.526, that took effect in February of 2018. It was actually narrowing what could occur during municipal rental inspections. And those are actually exceptions. So they can't go in if it's vacant, they can't go in if it's responding to a tenant complaint, or if the municipal inspector has a warrant for the inspection. So my tenant did complain. This is an inspection that's being scheduled by the plaintiff, which is perfectly acceptable in my eyes, but I don't wanna violate the fact that she's due notice under this statute.
Okay, just one moment here.
She's citing,
Hold on, council, just one moment. I pulled up 125.526, so please pull it up.
direct your attention to paragraph 7, Your Honor. It's actually paragraph
Hold on,
7.
council, just one moment. Except as provided in subsection 7 to 9 and 11, an inspector or team of inspectors must request and receive consent from the lessee to enter before entering a leasehold regulated by this act to undertake an inspection. So we'll read 7, 8, 9, and 11. 7, the owner of a leasehold shall notify the lessee of the enforcing agency's request to inspect a leasehold, shall make a good faith effort to obtain the lessee's consent for an inspection, and if the owner obtains the lessee's consent for an inspection, shall arrange for the inspection by the enforcing agency. 8, the owner of a leasehold shall provide the enforcing agency access to the leasehold for an inspection during reasonable hours if any of the following apply. A, the lease authorizes an enforcing agency inspector to enter the leasehold for an inspection. B, the lessee has made a complaint to the enforcing agency. C, the leasehold is vacant. D, the enforcing agency serves administrative warrant ordering the owner to provide access. E, the lessee is consented to an inspection, or subsection C. If a lessee is not present during the inspection, the enforcing agency may rely on the owner's representation to the enforcing agency that the lessee has consented to the enforcing agency's inspection. So it doesn't appear as though any of these apply. I don't have a copy of the lease that would indicate whether or not the lease authorizes an enforcing agency or the city of Wyandotte inspector to enter the leasehold for an inspection. However, the lessee has made a complaint to the enforcing agency, so that seems to trigger the owner being permitted to provide the enforcing agency access to the leasehold.
That's correct.
That would be 8B.
That's correct.
And then let's see, 9 is the lessee shall provide the enforcing agency access to the leasehold for an inspection during reasonable hours if any of the following apply. And then that's 4 of the previous 5 as well. And then 11, before entering a leasehold regulated by this act, the owner of a leasehold shall request and obtain permission to enter leasehold. However, in the case of an emergency, including but not limited to fire, flood, or other threat of serious injury or death, the owner may enter anytime. So it appears, council, that under MCL 125.526, 8B, Mr. Branson has authority to allow access to the home during reasonable hours. And 9 a.m. to 2 p.m. seems as though those are reasonable hours.
Thank you for the clarification.
Yes.
Are you
So-
recording, ma'am? Your Honor, I think
Hold
she's.
on, ma'am, are you recording these proceedings?
No,
Okay, where's your phone?
it's turned off.
Okay, please present it over here for a moment. Okay, here's what I'm gonna ask you to do. I'm sorry, no, hold on, Dave, I'm sorry. Can you please, enter your passcode? You don't have to show your passcode to the court officer, but put it in a spot just so that you're only entering your passcode and nothing else, please.
I have to turn on my phone first.
It's completely off?
Correct.
Okay. All right, I'm just gonna, so it's completely off.
Correct.
Okay, please hand it to the court officer for a moment. We'll leave it up this way. You'll get it back, people. You'll get it back when we're done.
Oh, wait a minute, no, you can't take my phone from me,
Yeah.
because you're not authorized to take my phone from me.
Yeah.
I'm not valid like you can neighbors.
Yeah,
I would like my phone back.
yeah, all I'm doing is just making sure these proceedings are not being recorded.
Correct, and they're not, but I have not reported them.
Yeah, I'm just indicating it's gonna be here for just a couple moments,
Oh,
and then you're gonna get it back. I'm not saying it's for hours, no, as soon as we're done with this, you're
oh
gonna
no,
get
I
it
want my
back.
phone back. The court is not authorized to take my phone.
Yeah,
Under what basis?
because there has been previous recordings
Not by me.
by, can you please not interrupt the court? By Ms. Collins, there is a concern that the proceedings are being recorded. So I'm just trying to alleviate any of the concerns, and it's just gonna temporarily stay right here. That's all I'm saying.
Can you please, under what law? that gives the court?
Under the judicial discretion that's given to the courts under the court rule that allows phones to be brought into the courts.
That you can take my property?
The court has judicial discretion as to whether or not to allow individuals to keep their phones. If you want to go put it out into your car, you can certainly go do that. It's just not going to be in the courtroom. So can you give her back her phone? You can go put it out into your car.
So because I'm friends with Ms. Collins, you're concerned that I will be recording?
No, ma'am, it's not because you're friends with Ms. Collins. There was a concern raised that there's potentially recording. You stated that your phone is off.
It is off, so
Okay.
how could have I been recording if you make it pay? I looked up here, my phone
Ma'am.
is shut down.
Ma'am, this court has judicial discretion to ensure that there isn't anything improper occurring regarding any recording.
Correct,
Okay.
and it isn't.
Ma'am, it has been raised, so all I'm doing for purposes of the proceedings
Right.
is for you to go take the phone out to your vehicle. I'm not arguing with you any further. I've explained the court's position, it can go out to your vehicle,
I will take it up from you.
okay? So, pursuant to MCL 125.526, 8B, the inspection is scheduled for February 25th from 9 AM to 2 PM.
I'm sorry, it's 26, Your Honor.
You said the 25th,
My mistake, I misread it, it's the 26th.
26th,
26, correct, 226.
okay, which I believe your client does not work on Wednesdays. If I recall from last week, I think she.
Thank you for that consideration. You may be more aware than I am.
I could be wrong, because I
Okay.
got the time wrong this morning when I sent the
Yeah.
letter, but I'm pretty sure that she works on the weekends and then on Tuesdays.
And I appreciate your patience.
Yeah, no problem. So, February 26th and from 9 AM to 2 PM. Counsel, when are you back in town?
Judge, I couldn't schedule with my kids, so I'm not going to.
What?
I couldn't schedule with my kids.
What does that mean?
Like, one daughter is finishing Northwestern Law School, she couldn't take the time off to go, so I canceled it. I'm not going out of town.
Oh, okay.
I
Well,
don't want to go without my kids, so I canceled it.
I was going to have everybody come back, well, I prefer for everybody to come back Friday, because, the inspection itself, I'm not saying it's a moot point, because obviously the property has to be inspected, but for these purposes, I don't know that that has a bearing one way or the other with what this court's ruling regarding the escrowed money. Because I believe that the issue that we have left to address is where does the escrowed money get released to whom does it get released? And Ms. Collins raised a concern regarding overpayment of the utilities. And so there's that issue. So counsel, when the two of you were out in the lobby waiting for the court to call the case, did you go over any of the utilities?
No.
No, Your Honor. Well, we can try to address it before the hearing on Friday.
Okay, I mean, since you're here, you might as well, while you're out in the lobby,
We can.
maybe look at it, or you can
But
maybe
the
even go
problem
over to
is-
the offices.
Ms. Collins isn't here, and because she's not here, I haven't been able to get anything directly answered. So I don't know how constructive it would be.
Well, counsel, were you provided any utility bills?
I was. I might need a moment and I might have to do it over the phone because there is some aggression outside in the hallway and I'm not comfortable.
I'm sorry, aggression?
Yes. I don't know how much I'm allowed to disclose because it's settlement negotiations.
I'm sorry.
Okay, all right, your aggression by,
Opposing counsel,
okay, verbally?
physically,
Oh, my Lord.
Okay, what specifically?
he was stepping, the woman Lily who just left the courtroom, you know, even if she shouldn't be involved in the conversation, I respect this, but he was physically stepping in front of her and pushing her back. I witnessed it.
That's not true, Your Honor. That's
It
a
is.
false statement. That is a false statement, Your Honor. We were having a private conversation. This young woman comes up and starts interrupting, getting into my face. So I turned my back, not wanting to confront her, because I didn't want to deal with it. You can see why from earlier what happened. I just don't want to deal with it. It's me and her. She's a very kind human being. I don't see any reason why anybody else can be involved in
Referencing Mr. Kalala.
I am.
For the record.
Yeah, you know, we've talked on the phone. She's a tenant in the building I built. The guy she works with is my childhood
This
friend,
is not
Scott.
relevant.
It is very relevant. Finish,
No, it
please.
isn't.
Ma'am, they're just producing issues for no reason at all. I'm willing to have any conversation with anyone, particularly Ms. Dakala, because I view her as a very kind human being. And I'm not sure where this hostility is coming from, other than the distraction for further noise.
Okay.
And that's something that
Hold on.
I'm trying to avoid.
Here's what I'm going to say. So, Miss Ariel or Miss Lily, I'm not sure what her name is, I thought she had
Ariel, I'm sorry, Ariel.
Oh, okay, she really has no point really in participating in the conversation between you and council. But what I'm going to say is we have a court officer that can be near the both of you, if, you know, for some more, so that you can feel a bit more comfortable.
Okay.
So we can do that,
If
because
you
I
could
do
be-
think it's imperative that as much as it can occur for council to be in the same room showing the paperwork that's there to be shown on both sides, as opposed to, you know, getting an email or talking on the phone or something like that. So if there was a court officer that's there, would you feel more comfortable with that?
A little bit, but frankly, you know, opposing counsel is a fantastic order, but I'm shaken up. I'm shaken up, you know? I'm not trying to cause a distraction. I can't deal with an overly aggressive person outside of the courtroom, even if it's, you know, when people aren't looking. If it's over the phone, fine. If it's words, fine. I know that Miss Ariel is not my technical assistant. I know that she's not technically involved in any aspect of this case as a party, but I don't feel well internally. That's the problem. And I need to go forward on this motion, this amended motion to dismiss, but I can't tell my client that she can't be here, can't participate. If she's insisting on being here, I have to respect that.
I didn't say she couldn't be here.
Right, and I know you didn't. But what I'm saying is that, to me, it's very clear what the situation is. And that if there's an eviction action, it needs to be done differently.
It's very clear.
Yes, I'm not gonna get into the substance of the matter of the amended motion to dismiss.
Okay,
I don't know what she's,
well,
I
okay,
don't understand what's going on here.
so
And
everybody can be back Friday?
Yes,
ma'am.
what time?
Your Honor, there's just one issue.
Hold on, let me, well, okay, does the issue affect Friday?
It does. Let me tell you why. If the court decides to see the video, we were told by the court clerk that we can't bring with us a stick that you can plug in. But what we've done instead is that we put it into a Dropbox. And I'm hoping, and I brought my assistant Ashley, because she's a lot more sophisticated with technology than I am. And so the only reason I've asked for her to be here is to facilitate showing the video if you decide to see it on the screen or multiple screens, however the system works. So that's about the only technical issue that I'm concerned with. I don't know how to do that, Judge. But if you know how to do it,
Your assistant can't be here on Friday?
no, Your Honor, she's going to Florida.
Okay, well, it's just about just make sure she has it saved on your desktop, and that way, when you do your screen sharing, you can access it and pull it on up.
Well, I was gonna ask the court, since we emailed it in a Dropbox to you, would you be able to do it yourself here?
That's not what we do, and I'll tell you why. Number one, and even though it may have come from the police department through the records, it's a way to make sure that we're not getting any viruses into our equipment. So, no, I'm not going to play it on my device.
She's just suggested an idea, if I may.
What's that?
She can appear by Zoom if it's possible, and perhaps we can do a screen sharing, and then it can be demonstrated on screen through screen sharing. Is that possible to do?
Yeah, that's fine, I mean, the sole purpose for your assistant is to play the video, correct?
That's right.
Okay.
I don't know how to do it, Judge. And in other courts, in circuit courts, we pre-arrange it. So what happens is that some sort of a cord is plugged from from the computer to the screen, and it plays on the screen. That's how we've done all the other video. But, you know, when I started.
I don't think there's a cord long enough for, I don't know.
When I started college, Judge, I swear to God, they didn't have any computers, they were using cards. You know, by the time I graduated, we got into the PC. So I'm not technically savvy. But at the end of the day, Judge.
Change with the times, Mr. Dagger.
Judge, I'm retiring next year. I'm almost 60. I don't really care. And I'm going back to the farm in South Lebanon and raise chickens. Think I'm kidding? It's true. I'm not joking. My grandfather lived to 95, and I intend.
I'm sorry,
to
can we limit the extra comments?
So,
Your Honor, with all due respect, counsel here has demonstrated a great deal of agitation to me, and now I'm in fear.
what are you in fear of, Mr. Dagger?
I'm in fear of being anywhere near counsel in being accused of something. So, I'm just letting you know on the record what I'm now fearing. I'm sorry that I'm a man and that I am who I am,
Gender has nothing to do with that.
but that's what she was suggesting, Your Honor.
No.
Okay.
Anyway, Judge, we'll be back on Friday, the 27th.
May I request that it's at 8:30?
Let me just double check what the docket is.
Okay.
I'm here all day, I don't have anything I'm presenting, so let me check what the docket is.
We're okay for 8:30 now.
Well, I mean, we'll do 8:30. There may have to be some interruptions where I have to move people in and out of breakout rooms and such, but we'll do 8:30. Everybody can be here at 8:30?
Your Honor, is there a Zoom login information that we can get now?
Yes, just one moment. Well, let me just confirm. I know I just said that there's, okay. So, 8:30 a.m. I'm going to ask that you both email me the briefs that were submitted via my file, just so I can have those to review in the event, I'm not sure when Ms. Perry-Askew is returning. So please email those to review. Please email to me the amended motion to dismiss and your response, Mr. Dagger, plus the video.
Your Honor, I actually did attach the amended motion to dismiss as an exhibit to my brief. Do you want me to do it differently, or is that sufficient?
Did you draft the amended motion to
No.
dismiss?
No.
Okay. No, that's fine, it can just stay the way it is. Mr. Dagger, though, I need the response, if you can email the response and just remove the video from the attachment.
We'll do that, Judge.
I'm sorry?
We'll do that, Judge. You also wanted the memos, I assume, Your Honor? You asked us to brief?
Yes, so that's what I did, I asked both of you to email the briefs that you submitted.
What's the email address, Your Honor?
27dc@wyan.mi.gov.
27dc.
dc@wyan.mi.gov.
You should already be copied on an email from me to that email address.
And then the Zoom ID is 656-647-7075.
Is there a password, Your Honor? No password, okay. Can I repeat that to you, Judge, just to be clear? 27dc@WANDOTTE.
Wait, W what?
WAWYO, is it YAN? Yeah, sorry, WYANDOTTMI.
There's an E at the end of the.
TTEMI.gov, correct?
WYANDOTTEMI.gov.
Got it, you got it.
Okay.
And the Zoom is 656-647-7075, correct?
No, 707.
Okay, she's got it.
I got it.
She's the one that needs it, so, okay. All right, and if you have any questions on that, it's on our website as well.
All right,
Okay.
Thanks again for all your patience.
so Judge, in terms of the inspection, it's not going to be in written form. Do you want us to submit it to you? We can do it now if you want.
submit what, the
The
communication
order,
from
the order of inspection, Your Honor. We can prepare relatively quickly and submit the signature, so that,
Oh, you can bring it on Friday, that's fine, because it's still before Tuesday,
yes, ma'am, we'll do that.
okay?
All right,
All right, anything else?
No.
Okay,
thank you,
all
Judge.
right, thank you. Have a good day. Let's
You
go
too.
off the record for a moment.
I'm not talking to her.
Utilities on Friday. Please bring all the documentation with you.
May I?
Hold on, let me go back on the record.
Okay, what we can do, Judge, with regards to utilities, I can have my assistant talk to her directly, or we can exchange emails. I won't be part of the conversation. I don't want to be physically in any place near her. So how do you, I'm offering her an opportunity to suggest she can talk to my assistant Ashley, or we can go back and forth in email. I'm not quite sure what would be more efficient.
Well,
In 32 years of practicing.
hold on, I'm not gonna get into all the, I'm not
Yeah.
getting into all the dissertation. Do you wanna speak to Ashley?
I would speak to anyone, I just, I mentioned he's being physically aggressive and now it's being pushed over onto me somehow.
Who's
So
pushing
I
it
don't-
over on you? The court's not pushing it over.
I just was no, not the court, opposing counsel, I was just mentioning I can't talk to him outside right now. I need a second to breathe.
I don't want
What
to
about,
That's all.
please, hold on, what about speaking with Ashley? You should, and the two of you can go over the utilities and kind of see where you're at. And then Ashley can get her steps in, go back and forth with Mr. Dagger, somewhere where he's somewhere else, and the two of you can have a conversation, you, meaning you and Ashley, can have a conversation regarding the utilities.
I have a panic disorder.
Okay,
Yes, I can go sit with Ashley.
okay, all right, so
I'm gonna
Ashley,
stay here.
I'm familiar with everything in the case and I would talk with her this.
okay, and then if there's any
I will go
questions,
back.
whatever, I'm gonna have you go back and forth with Mr. Dagger.
Yes,
But if the two of you have to have a conversation, then I'm gonna have the two of you, have that conversation outside the presence of, Ms. Tequila and Mr. Dagger. I'm gonna have you, cause I have some other matters that I'm, handling here, so if you have to have a conversation, then you have to step outside.
What I'll do is I'll sit next to the court officer, Your Honor, near the entrance, and I'll sit there and go back and forth.
That's fine,
I'm
we can open
not
up,
interrupting your court.
we can open up the, either the defense attorney room or the prosecutor room, so the two of you have a desk.
Okay, thank you.
Okay, thank you, we'll see you both we'll see you all on Friday. All right.
Thank you. Better leave first, please.
where would you like to go? I'm sorry.
You just wanna go out in the hallway?
Yeah.
Okay.
And Mr. Dagger, when they're discussing, whatever they're discussing, please do not make any comments, okay? At all, don't make any comments, or anything. I'm not suggesting that you will, I'm just,
Judge, I'm a father of two girls,
counsel.
and you have no idea how upset I am.
Counsel, I want everything to go as smoothly as it possibly can, okay?
I think you know how I feel.
Thank you,
Thank you, Your Honor.
okay.
Oh my gosh, guys, please comment down below what you thought about this hearing. It was so intense. I was invested till the end, and I will be here Friday for the update, you guys.